salary and sign-on fee or one salary reward or just a down payment, even if the criteria are not met in the court, this does not take away the opportunity for a party to terminate under Article 40 and still defend that they had just cause. So if you are the defensive lawyer and you see some cracks, some of the requirements are not met, you can't just think that it's a full stop, the case is over. No, it's not, because it's an arbitrator's job, we have an arbitrator here, to look into the Article 40 general rules of termination contracts. So be careful with that. Some people make this mistake. They think, okay, 40 this is not met, the player has not response. That's not the case. So let's go practical now. Let's go with the examples of case law. As I told you, I really hate the theoretical part. I love the practical part because there is my strength. By the way, what I'm teaching in Madrid is for the castable case law. And you've heard of Mike Ross from Suits, the movie? You can tell me a case and a paragraph number, and I can quote it immediately. I'm not joking. Actually, I also told you that. He's asking something I'm not sure if he's reading everything, by the way. Reading everything? So guys, the first case, it generally looks like a standard case, but things which are different from the standard case so that you can understand how important this operates. So here we had a player who was playing in China, and then he was sent on loan to a club in Latvia. And when he was sent on loan, the parties agreed between themselves, the player in the Chinese club, that the new club from Latvia will pay part of his salary, and the other part of his salary will still be paid by the Chinese club. This means that the Chinese club and the player suspended the player's contract, but not the financial obligations of the Chinese club to the player, at least part of it. And for that reason, the parties signed the usual way a supplementary agreement. When they suspended the employment contract, but agreed that part of the financial obligations of the club will remain enforced in that. And when the player went to Latvia, the club suddenly stopped paying. And then he went to put up on notice and he gave him 2 weeks. You can imagine the club defense was, first of all, the employment contract was suspended, so we don't have to pay you. And this supplementary agreement is a different legal instrument. So you can't terminate the employment relationship just because we are not complying with the supplementary agreement. Both those statements of the club were legally wrong because the supplementary agreement was actually part of the employment relationship. And by not paying the salaries, the club is in breach of contract. So suspend their relationship for a while the player is on loan away from the club. When they agree that certain financial obligations will persist, they will survive, the player has just cause to terminate that suspended contract even during its suspension, provided that there are at least 2 salaries due and there is a notice to the club. And this is what happened in this case, which went to CAS, and CAS resolved it in favor of the player. The player had just cause to terminate the entire employment relationship because 2 of his salaries from the supplementary agreement were not paid while he was on loan. So this is at the same time a general case because there are 2 salaries and 2 days notice. At the same time, there are 2 specifics. One is that there was loan, and second, that there was a novation of the contract with the supplementary agreement. If you have any questions on this case law, I'll be glad to answer them after the presentation. So you can take notes. If I'm going too fast, also let me know. But as I told you, they limit me to 20 minutes, which is very hard. Yeah, they are doing this is easy in Madrid. You know, I previously had 14 hours of students, and they were not enough. Now they want me to teach them in 6 hours, which is killing my spirit, you know. I can speak to them. Trust me, I can. All right, let's go to the next one. As you see, this case is so start with 10,000 number. That means that it's great risk. So for this particular presentation, I'm trying to bring some recent cases so that you know its actual one.
So can you put
This case
on
is
YouTube
also
and
very interesting because so far we had contradictory casts of jurisprudence on that matter. This case is about a player who sent a notice to a club after two sellers were not paid, and
during that break,
this
can you do
15-day notice was due to expire on a Saturday in a country where Saturday and Sunday are holidays, a weekend. So nobody works on Saturday in Europe. So the expiration should be prolonged automatically to the next business day, or we should accept that the player had just closed to terminate on a Sunday since the deadline expired on Saturday. And what happened in the past? In the past, the first decision is the one with red on the bottom. There was a decision between a Portuguese player and a Turkish club in which I was lucky to participate in. In that case, CAS decided that if the deadline expires on a holiday, it was in Turkey on January 2nd, a non-working day, it's not extended until the next business day. That's the first of a kind, the one we read. But then another arbitrator in CAS, which is a little bit more pro-club orientated because he works in the club as a legal director, he decided that Swiss law should complement the FIFA regulations, and if a deadline expires on a working day or weekend, then it should be extended under Swiss law. But you know, FIFA generally is not affected with the regulations. CAS does it, they supplement FIFA regulations with Swiss law, but that's not a rule which applies to the FIFA GRC, where the case first will be decided, and generally the regulations are not based on Swiss law. They're just interpreted in the Swiss law. So it was a task here for CAS to be a mess. You have to compile all the business and non-working days. Imagine, I live in Bulgaria. I don't know which day in Nigeria is not working. Whether you are having a holiday or a national holiday, I don't know that. And I might be tricked to terminate the contract, and then you come against me and say, I'm sorry, but today is Tuesday, we don't work in Nigeria on Tuesday. And I don't know that. And then it looks like I did a mistake. That's exactly why FIFA looked into the objective. And they wanted to be objective, but do not comply with the calendar in each country. That's why when a 15-day deadline expires on a non-business day, on a holiday, on a public holiday, that's when it expires. It does not extend any further. So imagine it expires on a Saturday, which is a holiday, you can still terminate on Sunday. And in fact, if a club wants to defend itself on this basis, they can do a lot of things. First of all, they can always pay the money even on Saturday by using online banking, so they can pay from home. Also, if they feel that they have the money, but they cannot transfer them so quickly on a Saturday, they can always act in good faith and ask the players' council to extend the 15-day period and say, look, give me 2 more days. Monday, I'll be in the bank, I'll send you the money. That's a good faith example. So there is always a defense against that. But when you're calculating the 15 days, and if they expire on a holiday, you can still terminate the contract without further extension. That's the key finding to take away from this case. Let's go to the next one. I strongly encourage everyone in this room who is interested in sports law to read this award in full. This award was recently published by CAS on the main website under the tab Recent Decisions. So you can easily find it on Recent Decisions, not on the jurisprudence website, but on Recent Decisions. And it's written by a British arbitrator, not known to me, but in a very, very, very good style and very sharp in legal findings. And this case is very interesting for 2 reasons. Let's give you the case overview just here. There was a player, Moses, who hired a lawyer. But it seems that the lawyer didn't do his job. Why? Because, first of all, there was a dispute over the player's payment of salary for September. Then there was also a dispute regarding his December salary. But then, when the lawyer put the club in default, in the notice, he mentioned by mistake November and December. He actually put in default the club for his players' salaries for November and December. There was no player's position was that his signature on the receipt was forged. So it was a disputable payment. But nevertheless, the warning letter sent by the Players Council did not even mention September. It claimed November and December. In fact, both October and November were already paid. So actually, he claimed a salary that was already paid to him, and there was no dispute about that. So the default notice to the player actually sent was actually incorrect, which was leading in the CAS decision. So let's go to the CAS decision. Why it's so important.
uh, Contents of the default notice, the procedural issue. CAS said that you have to specify exactly the unpaid amounts. No, no, let's go back. One. So CAS said that you have to specify the exact unpaid installments in the default notice if you want to benefit from 14 this. If you want to benefit from 14 this, be very specific about what the club has to pay, because otherwise you will be depriving the club from their right to defend themselves. Because in that scenario, where the player puts the club in default for November and December, the club can easily defend itself and say, look, here is an evidence. You already paid November, so you can terminate for November and December. I'm sorry, but we have an evidence. So the club has a valid defense against that. And then if the club gets surprised that the player terminates for non-payment of September and December, then it's not a valid termination because the club was never